Question? Okay, we are on the record now. KCR 2221-1623, State of Idaho versus Chad Daybell. This is another day of jury selection in small groups. The defendant is here present, represented by his attorney, Mr. Pryor. The state and prosecutors are here present as well. Apologies for the late start, counsel. We had a number of jurors that were late getting in. We have 14 of the 16, one we haven't heard word from, another is still apparently half an hour out, so we're going to proceed without waiting for that particular juror. The jurors that will not be appearing or have failed to appear, I'll read that off in a moment once it's been confirmed. The issue we can take up before we bring the 14 in that are here, a issue brought up this morning to the court regarding access the state has to NCIs that are exclusively in the possession and control of the state. The state's, as I understand it, made an agreement and did, in this case, as we started, to provide that information for review of the defense as it relates to check of criminal histories of prospective jurors. My understanding is the state has agreed that any information they intend to bring up on NCIC criminal history is going to be provided in advance to the defense prior to the groups coming in, the 16 groups of voir dire, and maybe I can just get a confirmation of my understanding on that issue from one of the prosecutors. Mr. Wood.
That is accurate, Your Honor, and just for the record, to be fully accurate, the state is allowed to share that information and allow Mr. Pryor to review those. We are not allowed to turn copies of it over to anyone outside of our office, but we will, anytime there is a criminal history, share that information with the defense.
All right, Mr. Pryor, is that arrangement acceptable to the defense?
Yes, Your Honor. Thank you very much.
Okay, thanks, counsel, for acknowledging that issue. The one other issue I will bring up briefly with counsel is on the juror affirmations of the jurors that have appeared this morning. One of them made some sort of an explanation that I'm not particularly concerned about, being asked about the case at work, but not talking about it. That would be juror 791. Does the state have any concern or think we need to address that comment in the affirmation?
No, Your Honor, the state did read over that comment. I think that that wouldn't be in violation of the court's order. It sounds like she tried to comply with what this court ordered her to do.
Okay, thank you. Any concern from the defense as to juror 791?
Judge, I don't know the level of the discussion that's referenced. I may not share the court's opinion in that regard. My concern is that I don't know what, again, how much of a discussion took place. It seems unclear. There obviously was an acknowledgement and there was some discussion. I'd like to know the level of that discussion. What I am concerned about is whether there's been a change in the form of opinion or not. If there were facts discussed, issues discussed, feelings of coworkers discussed, and that sort of engagement took place, you can't unring the bell. And I have a concern about that. So I would like the court to allow some further inquiry into that regard if that particular juror is going to be here.
Okay, well, when that comes up, Mr. Pryor, that they did state there was a discussion. They said they kept the discussion to a minimum, so I think that is an appropriate line of inquiry on voir dire. If you have further questions about that discussion and this juror's following of the affirmation, I'll permit that. Likewise, the state's permitted to inquire on that issue also. The jurors now that we've confirmed are not going to be appearing as part of this group would be jurors number 823 and jurors number 1112. So the remaining 14 jurors from this group are here. We will proceed then with bringing those jurors in to continue with our voir examination of them. Is there anything else the state needs to address before the jurors are brought in?
And Your Honor, just to be clear, and I may have missed it, is the court going to excuse those jurors or are we bringing them in later?
Well, we've got the one group today, so at least the one juror that's on their way is going to be instructed to return likely tomorrow morning. The other juror we haven't heard from, so I'm not sure.
Thank you. I just wanted to make sure that we kept them in the pool if they may still be coming back.
Okay, I'll confirm who's who and what happened and whether we get any word from the other missing juror. And when we conclude this group today, I'll let counsel know if and when these particular jurors are going to return for further voir. Beyond that, anything else from the state before the jury's brought in?
Nothing further. Thank you, Your Honor.
Nothing, Judge.
Okay, Ms. Bailiff, if you'd please have the jurors brought in then.
Yes, Your Honor. All right, please. Counsel, here you are.
Thank you. Please be seated. All right, good morning, everyone. We're on the record on case CR 2221-1623, State of Idaho versus Chad Guy Daybell. I'll note that the defendant is here present, represented by his attorney. The state's present as well, represented by the prosecution. Before we begin the jury selection process here this morning, I'll first inquire, beginning with the state, is there any objection to the manner in which the jury panel has been recalled and seated today?
No, Your Honor, thank you.
From the defense.
No, Your Honor, thank you.
All right, thank you, counsel. At this time then, I will note on the record, we had 16 jurors summoned to appear today. Juror number 1112 has failed to appear, and juror number 823, for some reason was running substantially late and is going to be instructed to return for another group, likely tomorrow. The remaining jurors have all arrived and reported, and thank you for coming today. Let's next have a roll call by the clerk, if we could, to confirm who's here. And when your name's called, you can please raise your red number so that we can confirm where you're seated also.
I'd ask you to please answer audibly when I call your juror number. Juror 752.
Yes.
Juror 791.
Yes.
Juror 792.
Yes.
Juror 899.
Yes.
Juror 909.
Yes.
Juror 922.
Here.
Juror 923. Juror 924.
Yes.
Juror 937.
Here.
Juror 951.
Yes.
Juror 1004.
Here.
Juror 1032.
Here.
Juror 1048.
Yes.
Juror 1057.
Yes.
Thank you.
All right, thank you, Madam Clerk. Ladies and gentlemen, thank you for returning this morning. You've been recalled here as prospective jurors in the case now before us. I'll reintroduce my court staff and myself again. I'm Stephen W. Boyce, the District Judge for Fremont County, Idaho. I'm in charge of this trial in the courtroom here today. Our court clerk assisting this morning is Shannon Holstein, and she's keeping minutes of these proceedings and will administer oaths to you as jurors. The marshals are here also assisting, maintaining courtroom order. Deputies Holmes, Page, and Ravello are here, as well as the court reporter, Mary Fox, who's taking a stenographic record of everything said during the trial proceedings. Also, my staff attorneys, Courtney Stalling, seated to the right, and she assists me with legal research and issues that arise during the case. You are all qualified to serve as jurors of this court, and each of you filled out a questionnaire that's now been reviewed by the court and the attorneys, and it was determined you would be recalled here for further questioning today. What we're doing in the trial at this stage is to select 18 jurors, which will be 12 jurors with 6 alternates from among you. At this time then, to assist you in understanding and participating in the jury selection process, I'll reintroduce you to the parties and their lawyers and summarize what the case is about. Before I do that, I will note with that juror that failed to appear, the court will issue an order to show cause and determine whether or not that juror should be subject to a fine and/or jail for failing to appear pursuant to provisions of Idaho Code, Title VII and Title II. At this time then, to introduce the parties, beginning with the state, I'll sometimes refer to the state as the prosecution. If each of you would stand as I mention your name. In this case, the state is represented by Lindsay Blake, who's the Fremont County, Idaho prosecutor, Rob Wood, Madison County, Idaho prosecutor. Ingrid Beatty is a specially appointed prosecutor, and Rocky Whitson, a deputy prosecutor also. The defendant in this case, Chad Guy Daybell, is represented by his attorney, John Pryor. Good morning, ladies and gentlemen. This case is a criminal matter, meaning the defendant is charged by the state of Idaho with violations of the law. I previously read to you, when you filled out your questionnaire, the amended indictment, and with regard to the defendant, then the state of Idaho has alleged that Chad Guy Daybell committed the following crimes, as alleged in that amended indictment. Count 1, conspiracy to commit first-degree murder and grand theft by deception. Count 2, first-degree murder. Count 3, conspiracy to commit first-degree murder and grand theft by deception. Count 4, first-degree murder. Count 5, conspiracy to commit first-degree murder. Count 6, first-degree murder. Count 7, insurance fraud. Count 9, insurance fraud. Mr. Daybell has pled not guilty to the charges. Please remember, that is simply a description of charges. It is not evidence. Under our law and system of justice, every defendant is presumed to be innocent. This means two things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove his innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crimes beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from lack of evidence. If after considering all the evidence, you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. I'll next discuss your duty as jurors. The duty of the jury is to determine the facts and then apply the law set forth in the instructions I will later give you to those facts. In this way, you will decide the case. In applying those instructions as to the controlling law, you must follow those instructions regardless of your opinion of what the law is, what the law should be, or what any lawyer may state the law to be. During the course of this trial, including this jury selection process, you're instructed that you are not to discuss the case among yourselves or with anyone else, including any use of email, text messaging, social media, or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. Do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. At this time then, I'm going to ask our clerk to administer an oath to the entire jury panel for this voir dire examination. Ladies and gentlemen of the jury, if you would please rise at this time and raise your right hands.
Do you solemnly swear or affirm that you will truthfully answer such questions as may be asked of you by the court or counsel, such upon your qualifications to sit as a trial juror in the cause now on trial, so help you God?
Thank you. Please be seated. I'll note on the record, the court observed that all the jury panel was placed under oath for this proceeding. At this time, I'm going to ask another question regarding this impaneling. Will the attorneys stipulate, beginning with the state, that the jurors now have been properly called and impaneled? Does the state so stipulate?
Yes, Your Honor, thank you.
Thank you. Will the defense agree?
Yes, Your Honor. Thank you.
Thank you, Mr. Pryor. The jurors have also completed their juror affirmations this morning, and the court appreciates you following the court's admonishing instructions. At this time, I'll discuss now the nature and purpose of this voir dire. This is the part of the jury selection process where you will be asked questions touching on your qualifications to serve as jurors in this particular case. This part of the case is known as the voir dire examination. Voir dire is an ancient Anglo-Norman term dating back hundreds of years to the origins of the common law. In Old French, it simply means to speak the truth. Voir dire examination is for the purpose of determining if your decision in this case would in any way be influenced by opinions which you now hold, or by some personal experience or special knowledge which you may have concerning the subject matter to be tried. The object is to obtain 12 persons who will impartially try the issues of this case upon the evidence presented in this courtroom without being influenced by any other factors. Please understand this questioning is not for the purpose of prying into your personal affairs, but only for the purpose of obtaining an impartial jury. Whenever you need to answer a question, please raise your red card so we know who on the record is speaking. And when you're called upon to speak, because we are making a record, please communicate verbally your responses, such as answering yes or no instead of nodding your head or shaking your head, and try to avoid speaking at the same time as any attorney questioning you or the court so that the record is clear for our court reporter. If you have an answer to any question that you feel is too personal or embarrassing to you to answer publicly, please let me know and we can discuss that in a more private setting. I will acknowledge here that we are live streaming this proceeding. However, jurors are not part of that broadcast. However, your verbal responses are being broadcast on that. You're just not being shown on any video. Similarly, if you think you have an answer to a question that may prejudice other jurors for information you may know about the case, please refrain from saying anything about the facts of the case, and we'll discuss that outside of the presence of your fellow jurors as well. At some point, we will discuss with each of you individually as needed your exposure to any pretrial publicity in this case or facts of the case. I will now read you a special instruction in this case, which is as follows. The defendant, Tammy Daybell, has been charged in the amended indictment with certain counts of entering into a conspiracy with Lori Vallow Daybell and or Alex Cox. The crime of conspiracy involves an agreement by two or more persons to commit a crime. You must only consider the evidence against the defendant in this case and should not speculate as to any other case or legal proceedings involving the alleged co-conspirators. You must remember that the defendant has the presumption of innocence, and you must consider his guilt or innocence based solely on the evidence provided in this case. That concludes your special instruction. At this time, I'll also ask that the attorneys be mindful to not repeat questions already asked by the court or other counsel. The attorneys do have the right, however, to direct any follow-up questions to a juror regarding that juror's response to previous questions. The jury should be aware that during and following the voir dire examination, one or more of you may be challenged. Each side has challenges for cause, which means that each side can ask a juror that a juror be excused for some specific reason. In addition, each side has peremptory challenges, meaning they will be able to exercise challenges without giving a reason for the dismissal. If you're excused by either side, please don't feel offended or feel that your honesty or integrity has been questioned. It has not. I'll now begin the court's portion of the voir dire process, after which the attorneys for both parties will be given an opportunity to make their own inquiries. When I'm addressing questions with the jurors, please pay attention to those questions because you may be called to ask or answer those same questions later. The first general question I'll ask to all of you as a group is regarding your questionnaire. Are the answers given by each of you in the juror information and in your juror questionnaire you filled out last week still true and accurate? If those answers are still true and accurate, please raise your red card at this time. All right, every juror indicated their answers are still true and accurate. The next issue the court wants to discuss is the time commitment required for this case. If you're required to serve as a juror in this case, it will be for a period of approximately 8 to 10 weeks. Would that period of time create a serious hardship upon you or your family or your business or profession or occupation so as to prevent you from rendering service as a fair and impartial juror in this case? If you believe that it would be a hardship for you to serve, please raise your red card at this time. Okay, we have a number of those. If you please hold those up for a moment, I'm going to list those out, let counsel do the same. All right, thank you. We'll take up these hardship concerns first with the group. We'll start with juror number 792. So give me a moment, I'll look at the questionnaire. And during this phase, I may have the counsel inquire as well on specific hardship questions during the first portion of the voir dire here. So juror number 792. You got a couple of personal issues you brought up there, in addition, employment concerns. Can you explain what you think would occur if you were required to sit as a juror in this case for that length of time?
I was out of work for about 10 months, started a new job about 5 weeks ago, so just getting my footing.
Is that new job a full-time employment?
Yes,
Have you discussed with your employer the possibility that you would be required to serve on this jury?
yes.
And what did they indicate would be the status of your job if you were gone that long?
Maintain the job, no pay.
Okay, so you wouldn't lose your job, but you would not be paid for the term you were gone?
That's my understanding.
Any follow-up voir dire from the state?
No, Your Honor, the state also had a note on the hardship to follow up. I think given that additional information that he would receive no pay during his service here, the state would make a motion to remove him for cause based on hardship.
The defense is going to stipulate to releasing him for cause, judge, in this situation.
Okay, well, given your employment situation with that new job, just coming off a term of unemployment, the court finds that would likely create a serious financial hardship for you, given the length of this trial. So for that reason, juror 792, I will sustain the for cause challenge based on a hardship. So thank you for coming in and filling out your questionnaire. I'll allow you to be excused. You can please return that questionnaire to the bailiff on your way out. Let's next talk to juror 899. Did you raise your card, please? Did you raise your card about a hardship also?
I did.
Okay, thank you. I note in your questionnaire, you didn't mention something on that. Can you explain to the court what the hardship would be?
Yes, my husband's job is ending in May, which means that I will be making up more than 50% of our income, and I'm afraid of losing our home, not being able to pay our mortgage until my husband can find another job.
When in May would that be occurring? Do you know?
He said that towards the end of May. I'm not entirely sure.
If that did happen and you were here doing jury duty still through that time period, do you believe that would become a significant distraction for you to be concerned about your financial situation?
Absolutely.
All right. And again, counsel, this one didn't have an indication here in the questionnaire, but that's why we bring jurors back. So I'd like to have a little more voir dire from the state and the defense to make a determination, beginning with the state.
Your Honor, the state did not have the note of hardship. We did intend to talk about some other things, but given that information today, I think the state would simply make a motion to excuse this juror for cause based on hardship.
All right, Mr. Pryor, response for the defense.
Judge, I'm inclined to agree with the state, but if the court would like me to elaborate a little bit on the level of that hardship, I would, but I think given the circumstances, I'd stipulate. I'll defer to the court. If the court wants before I elaborate some more, that would be fine, but given the statement, I feel that the distraction of worrying about having a home to live in is significant enough.
Okay, juror 899, I guess I'll just follow up briefly. You indicated you thought this might put your housing situation in peril if your husband's job ended and you were not available to help support family financially. Is that correct?
Yes.
Okay, based on that concern, I do think that would pose a significant distraction for you during the course of the trial and a potential financial hardship. So the court is going to accept your representations on that issue and allow Juror 899 to be excused based on a motion to strike from the state without objection from the defense. So thank you for coming in last week, filling out your questionnaire and returning today. You can be excused with the thanks of the court. Please drop your questionnaire off to the bailiff. Next, talk to juror number 923. All right, juror number 923, you've expressed a concern in your questionnaire about both being a student and working. Could you elaborate on why this would create a hardship for you?
Yes, my classes probably go into mid-May and I'm in mode. We're not able to focus on those. And then I do work full time as well, and balancing the shifts could be kind of hard. And then if I wasn't to work, I would probably lose my apartment.
Have you discussed your potential service with your employer?
It's really mentioning pays for the time. I can ask about that. They didn't say anything about it, so I don't think that I would pay, or they wouldn't.
All right, does the state wish to follow up before Dyer?
Your Honor, the state actually already had a note here as well on hardship. We had noted that she indicated she was a full-time student and that she worked full-time. I think given that additional information, just going off what we know today, it sounds like she would not be compensated for her missed work time. I think all three of those things together would create a hardship. So the state would make a motion to excuse juror 923 for cause based on hardship.
All right, Mr. Pryor, as to juror 923.
Judge, I was also going to request that the court excuse 923 hardship as well.
All right, juror 923, then the court will sustain the strike raised by the state and agreed to by the defense, allowing you to be excused for hardship. Thank you for completing your questionnaire and returning today. Please drop your questionnaire off with the bailiff on your way out. Next, talk to juror number 924. In your questionnaire, you stated, I have work out of town. You didn't have any other detail. Could you describe what type of work that is, when that would be out of town, and how it would impact you if you were during trial?
Yeah, I'm a musician, so I travel to other towns to play music. The work isn't always set. It kind of comes in as I go. So like in a month from now, I don't exactly know where I'll be, but generally the work is Thursday, Friday, Saturday, Sunday. So that just makes it impossible for me to leave town.
And is that your sole source of income?
Yeah, my wife and I are together and we kind of share our incomes. So it is my sole source, though, yes.
Inquiry from the state.
Your Honor, we also have, excuse me, had noticed that hardship of having to work out of town and had planned on following up. But given the additional information today, the state does believe that this would pose a hardship for juror 924 and would make a motion that he be excused for cause based on that.
All right, from the defense, Mr. Pryor.
Judge, I also had a note to excuse this juror for hardship based on the fact that he has to make a living traveling outside of town, and I think that's a significant hardship, having to try to make a living, perform jury service while he's also trying to travel out of town to attempt to make a living. So I would excuse me about that.
All right, court's considered the challenge there, given that that is your sole occupation and source of income. The court will sustain the challenge 924 as excuse for hardship. So thank you for completing your questionnaire and returning. You can drop that off with the bailiff on your way. All right, juror number 937. Thank you. You put quite a bit of detail in here in terms of what was going on with scheduled medical appointments, et cetera. I reviewed that. It is a concern about a hardship. Are these appointments that could possibly be rescheduled, or would that be too difficult?
No, they could not be. Most of these appointments were scheduled months ago. One of the ones I get are Botox shots for migraines, and if I don't schedule that the day I get them, I wouldn't get another one in 3 months. So it's when my next shot's due in May, and schedule for that.
Okay, and those are specifically for management of migraine headache pain?
Yeah. And I still get that, so it makes them less frequent, less severe. So some of it's medical appointments. I'm a single mom widow, and I have to take my minor daughter to a couple of doctor's appointments as well. So I'm the only parent that can attend those appointments. I usually work little bits of time off and out of state because of a long story anyways. But I am getting short on money, and I may very well need to take another short-term job before we're planning on moving to Oregon, because I may run out of money and not be able to pay the bills. So I can't do that if I'm working to trial for 8 to 10 weeks.
All right, I appreciate your explanation from the state and follow-up order.
Thank you, Your Honor. We also had marked down to talk further with juror 937 about the listed hardships. I think the court already went over the questions with regard to rescheduling and that kind of information. Given everything from juror 937, the state would make a motion to remove her for cause for hardship.
All right, from the defense.
Judge, I concur in that motion. I had her marked as being excused for hardship.
All right, juror 937, thank you for your service in completing the questionnaire. I'll sustain the motion of the state without objection of the defense that you've stated a sufficient rationale for a hardship preventing your service in this case, given the length of the trial. So juror 937 may be excused. Please drop your questionnaire off with the bailiff on your way. Next, talk to juror 1004. All right, raise your card, please.
Yes, Your Honor.
Thank you. In this case, you didn't indicate anything in the questionnaire. Would you please explain what's going on that would create a hardship at this point?
Yes, Your Honor. As far as employment goes, I'd be able to retain that. And I'd basically be FMLA and a protected pay. So it'd be coming out of my pay account for my time I've built up. It would require additional staffing to be called in to fill my position due to the nature of my job. The additional issue would be with childcare and the cost of childcare. My wife's current job that she'd be getting soon would be essentially a 9 to 5 every week for the foreseeable future. And if I was required to attend here, I'd have to provide childcare for my 3-year-old, and then also for my 12-year-old, and my 15-year-old is currently employed, and I help with his mom to take him to and from his current employment as well. So being unavailable to be there for that would create significant issues, again, with child cost to even find childcare for them. And also, I'm sure their mom would take issue with me not being able to take them on the days that's currently scheduled for me to have them.
All right, you're currently a police officer, is that correct?
Yes, Your Honor.
And are you saying that your department won't, or your employer won't cover jury service?
So I believe they will. I'm not clear. I've discussed with them the potential of needing to be here. I'm a little unclear, and that's entirely on me as far as exactly how that pay would go. I certainly would be compensated and certainly wouldn't lose my employment. But due to minimum staffing requirements for our department, if I wasn't available, there would be frequently days where other members would have to be called in on their days off to fulfill my position.
Okay, thank you for the explanations from the state. Any Bordar?
Your Honor, I just would like to clarify. I think I understood correctly. The concern sounds like when your wife's at work, you provide the childcare.
So I will clarify. So my current wife is the one that's beginning a new job. Her and I have my 3-year-old daughter together. My ex-wife is the one I have my 15-year-old and 12-year-old with. We have a custody schedule. And I would get them for, part of the week, and she gets them for the other part of the week. So if I was unavailable, per the agreement, she would be the first one I'd have to ask to cover for that. If she was unavailable, then it would be a child care issue trying to find care for them. Not so much for my 15-year-old, but getting him to and from his place of employment so he didn't lose his job and just began as well. So it'd be a custody potential issue if she wanted to make it, which I wouldn't be surprised if she did. But then for my current wife, it would be just the cost of finding constant daily and long-term care for my 3-year-old.
Because when your current wife starts her new job, you would be providing the childcare for the 3-year-old at times at least?
Yes, ma'am.
Okay, I just wanted to make sure I understood that. And you do not have childcare already set up or anyone in place?
So
Is that correct?
we do have someone in place. I'm not sure if she's going to be able to fulfill every single day of the week during the normal work week. Right now, due to the way our schedules work, she watches my daughter. There's only a couple days a week that we need coverage just because we've adjusted our schedules to where we actually work opposite sides of the week. And there's only a day or two here and there where we actually need coverage. Other than that, we just switch off with those duties.
Thank you for that additional explanation. I just wanted to make sure I understood correctly. Judge, given all of that, I think it does rise to the level of a hardship, and the state would make a motion to exclude Juror 1004.
Mr. Pryor.
Judge, I'd also agree that 1004 needs to be excused. As a lawyer, I'm well aware of the difficulties when there are ex-wives and these trying to navigate through custody and the impact actually on your 2 teenage children. That has to be taken into consideration, along with the fact that the financial burden of having to provide additional child care for your children. I think it's necessary that you be excused. I don't know that we should force him that burden.
All right, I'm considering this one. Juror 1004, in your questionnaire, you indicated that your current wife is also a police officer. Is that correct?
That is correct, sir.
All right, having considered the challenge here, the court is going to deny the challenge to strike. I don't find that there's a for-cause hardship represented by this prospective juror rising to the level that they would be unable to serve in this case. While I understand that may be hugely inconvenient if the trial really goes as long as we've scheduled, it's an inconvenience for anyone required to sit for that length of time. And based on that, juror number 1004 will remain in for further individual questioning or group questioning. All right, the next hardship issue raised was by juror number 1032. All right, thank you. All right, this juror's requested a hardship excuse in the questionnaire, talking about employee training and employment issues, and also issues with tending to children, including a special ed child. So would you please describe to the court in a little more detail about how this may impact your employment as well as your family issues involving your children?
Yes, so as far as the employment, I verified that I will get paid for at least 6 weeks. We're still rolling that up the chain to make sure that it would go to 8 to 10 weeks. So I'm pretty confident that I would get paid. The inconvenience and hardship would be more family related. My wife and I are the sole providers here. We have no family, no caretakers. I'm the one in the morning that makes breakfast, gets her girls ready. She has to leave the house by 6:45. She's a special ed teacher. To clarify, our kids are not special ed. She's a special ed teacher. For example, the past week when I had to come for jury duty, and today she has to show up to work 3 hours late. It's kind of a ripple effect on her. Our schedules, the pickup schedules to the 6 and 3-year-old that we have. To add icing to that cake recently, we just had a family diagnosis of cancer, stage 4, which is out of state, and we've been trying to monitor it. Hopefully it doesn't turn into the worst case scenario, but she may have to travel depending on the circumstances in the next 4 or 6 weeks. We hope it doesn't get to that level, but there is a possibility that she may travel, and if she travels, that kind of leaves me in limbo with the kids, kind of uncertain.
All right, thank you for that explanation. Let me go on to the state then and ask the state if they have any board dire on the hardship request.
Judge, the state does not have any questions at this time.
All right, Mr. Pryor.
Sir, all of these things, the thought of, I'm sorry about the cancer diagnosis, I really am. All of these things that you just talked about are going to be distractions for you. That'd be fair.
I think that's fair.
And these distractions, are they going to be in any way impact your ability to listen to the testimony and make a fair and impartial ruling? In this case, is this going to be something that you're going to be thinking about and not focusing on the significant importance of this case?
I think that's safe to say my mind will be wandering on other things, yes.
Judge, based on that, I'm going to move to excuse this juror for cause.
All right, based on those further responses from the state, response to the motion to strike.
Your Honor, the state has no objection.
All right, given those previous responses, juror number 1032, the court is going to find that service in this case would constitute a hardship, disallowing their service. So I'll sustain that defense motion to strike, and you can be excused with the thanks of the court. Please return your questionnaire to the bailiff on the way out. All right, I believe that concludes discussion of hardship with this group of jurors, and thank you all who are remaining here at this time. The next matter we'll go into.
We approach just briefly.
Yes. All right, we're back on the record. I had a brief sidebar with counsel. On the issue of hardship, we had one other juror that we just wanted to talk to about that, juror 752. Thank you. You did indicate in your questionnaire you believe you had a hardship. We didn't discuss that, and I don't see that you raised your card. It was work-related issues. Do you have anything to indicate on that, or have you resolved any potential hardship, and would you be able to serve given the timing?
So I am currently the CFO of the entity that I'm at, and I know everybody has time commitments, hardship and stuff. I do have a stay-at-home wife. I have spoken to the CEO of the company to let him know we're trying to figure out backup plans. I didn't, like say, I didn't feel we could potentially work around it, but if I get sequestered, that become issues around month end, quarter end. Those are always tough times. But I just feel like everybody has those commitments, work commitments. I didn't want to make it a bigger deal just because that I'd be different.
Okay, well, I appreciate that. With that in mind, then you do believe you, if required to serve here, would be able to do it and give this your full time and attention if that was the requirement and you were selected?
Yes, I do.
Okay, thank you for your responses on that. With that, if council has any further questions, I'll just allow that in the section of voir dire, and we'll pass over remaining for hardship questions and move on. The next matter we're going to discuss relates to your potential knowledge of the case. You have heard a summary of the charges made in the amended indictment. Other than what I have told you, do you know anything about this case, either through your own personal knowledge, by discussion with anyone else, from anything you've read or seen in the internet, newspaper, television, radio, noting this is a highly publicized case, so many jurors have heard of the case. And if you have, we will discuss that. And again, the details of that will be discussed individually with you, so don't bring up any facts. But if of these remaining jurors, if you have knowledge of this case, meaning more than just what you heard described by the court, would you please raise your red cards now? Okay, so we've got most of the jurors here, and if you'll keep those up for a minute, I'll get these all noted as well as counsel. Okay, thank you. We are going to move on. We'll note that and discuss that information with you individually as you're brought back in once we conclude the group questioning here. Next issue I want to bring up is, as it relates to the charges in this case. I've read to you more than once now what the charges are, but this case has charges involving murder, conspiracy, and insurance fraud. Is there anything about just the nature of those charges or the subject matter of the case that would make it impossible or difficult for you to fairly and objectively evaluate the evidence in this case and render a fair and impartial verdict? Okay, no one affirmatively answered that. I'm going to next ask some questions that might seem very obvious based on your questionnaires, but I'm required to go through these on some Idaho statutory authority to make sure there's no connection between you and any participants of this case. So next question, are any of you related by blood or marriage to the defendant, or do you know him, Mr. Daybell, from any kind of business or social relationship? All right, no one answered yes. I'll next ask about any legal relationship you may have with participants here. Does the relationship of guardian and ward, master and servant, employer and employee, creditor and debtor, landlord and tenant, boarder or lodger exist between any of you and any of the attorneys here today? No one affirmatively answered that. Are any of you a party in any civil action, civil lawsuit against the defendant, Mr. Daybell? No response to that. Have any of you ever brought a criminal complaint against Mr. Daybell or been accused of a crime by any of the 4 prosecuting attorneys that are here present today? No one responded to that. Do any of you have any kind of an attorney-client relationship, previous or current, with Mr. Pryor or his law firm? No one responded to that. Do any of you believe you've already formed or expressed an unqualified opinion that the defendant is guilty or not guilty of the offense charged? And if so, please raise your red card if you already have an opinion of guilt. All right, we've got one, Juror 1057. And we will discuss that with you individually, 1004 and 951. And then we'll discuss that with you individually. Somewhat related here, do any of you have any bias or prejudice either for or against the defendant, Mr. Daybell? No response to that. Are any of you unwilling to follow the court's instructions to you as the jury as to the law that you must apply in determining this case? No one responded to that. Do any of you have a religious or moral position that would make it impossible for you to sit in judgment of another or to render a fair and impartial verdict? No one responded to that, and I'll note we will ask you further questions individually that may cover that topic as it relates to the state's notice of intent to seek death penalty in this case. Are any of you, if selected as a juror in this case, unwilling or unable to render a fair and impartial verdict based upon the evidence presented in this courtroom and the law as instructed by the court? All right, no one said yes to that. A final catch-all question here. Do any of you have any other reason why you could not give this case your undivided attention and render a fair and impartial verdict? No one answered that question either. At this time, then, that concludes the court's portion of voir dire. I'll now allow the state to have its voir dire followed by the defense, who's going to be doing voir dire for this group today.
I will be, Your Honor.
All right, thank you, Ms. Blake. If you'd like to go ahead and question the jurors, you may do so.
Thank you. And thank you, ladies and gentlemen, for being back here this morning. I know this one's been a bit of a longer process and you were all here last week to fill out some questionnaires. So we appreciate you hanging in there with us while we go through this. The reason that we go through this whole process is we want to do our best to ensure that both the defendant, Chad Daybell, and the state get a fair trial. And so as we go through questions today, that's what we're looking at. That's why we're asking you questions. So as we go through this, I don't mean to put anyone on the hot spot or in the hot seat. So I hope no one feels that way, but we may ask you some questions as we go through this. If I use the term brutal honesty, what comes to mind? Juror 1048. If I use the term brutal honesty, what does that make you think of?
It makes me think of just telling the absolute truth. No falsehoods, no lies, just straight facts and straight truth.
Thank you. And juror 909?
Just that you would be completely honest regardless of how it might make the other person feel.
Thank you for that. And the reason I bring that up is as you sit here today and answer these questions, we're going to ask you to be brutally honest. And so it's part of the process today. And then if selected as a juror, at some point, you're going to go back with your fellow jurors when the court instruction says you can start talking about the evidence and what you've heard, and you're going to start having discussions. And we want to make sure that anyone here can be brutally honest both today through this process and also when you go back into that group setting, that you can be brutally honest with each other and speak up. So that's why we talk about that. And I don't know if any of you know, to me, when I think of brutal honesty, my niece, one of my nieces comes to mind. So she was my first niece, and as this little girl, I quickly learned if I wanted to know the truth about something, I could go to her. If I wanted to really know how my hair looked that day or how an outfit looked, she did not hold back. She let me know. And I think we probably all know somebody like that, that whether it's a little kid or the filter, and I don't know if all of you know someone like that, that's kind of your go-to to get that straight answer. And Juror 1057, I think I saw you nod at one point. Do you have someone like that in your life that will just give you that straight answer? The judge talked to you about the subject matter of this case, and we didn't have anyone raise their hand that they couldn't sit on this. As you're aware, this case does deal with several counts of conspiracy to commit first-degree murder, as well as several counts of first-degree murder. There was a question on that questionnaire. Some of the images that you may see in this case may be graphic, they may be disturbing. It's normal and it's fine to be disturbed by these images, but I just want to check, is there anybody on the panel today that have seen images of, say, children, and maybe not the best images, graphic images, disturbing images? Is that going to cause anyone here concern that they couldn't be fair and impartial? Juror 1057. Let's talk a little bit about that.
It wasn't children, but my brother-in-law caught on fire and I put him out. And it's been a long time. And after filling out this and being here, more of those thoughts come to my mind.
Of what you saw that day?
Yeah. And smelled.
So in your mind, if you were, and that's a fair answer, and so not trying to put you on the hot spot, but just asking a few more questions. For you, if you were to see images, would you be able to set aside any thoughts of your brother-in-law and be able to just look at the images and give them the weight you think they're due in relation to any other evidence presented?
I think I could.
Do you think it would be so upsetting that it would cause you any kind of physical or mental anguish to the point that you couldn't be fair and impartial?
I don't know if I can honestly answer that, but I do know that I've been having trouble sleeping.
And when you say trouble sleeping, did that start, do you mean since you've been selected to potentially be a juror?
Yeah.
And do you feel that's impacting your life in such a way that it would affect your ability to sit as a juror in this case?
I would hope not.
Thank you for your honesty. When I talk about brutal honesty, that's exactly what I'm talking about. Has everyone here flown on a plane before? I see, I think everyone nodded yes. So when you get on the plane, you probably recall at some point they kind of tell you, hey, sit back or lay back, enjoy the flight. We're going to arrive at our destination at such and such time. If instead of getting that announcement, the pilot told you, hey, so I'm going to try to land the plane. I think we'll get there at this time and hopefully we land. Would you feel comfortable staying on that plane? I see a few people didn't respond completely. I saw a lot of shaking of the head. Juror 752, would you feel comfortable staying on that plane?
Not knowing, I like to know where I'm going, and if there's uncertainty, I'm going to be questioning it, trying to see if we can get some answers. I don't like just sitting blindly and just following. I'd like to see what's going on.
And I appreciate that. Juror 922, how about you?
I prefer my pilot to be competent and confident, I would say.
And I think those are both very fair answers. So if you have the choice and you could get on a plane where the pilot says, I can for sure land this plane, and the other plane, the pilot says, I might be able to land it, which plane are you getting on? And I'll ask Juror 951, which plane would you get on out of those two?
The one, the pilot being confident of getting to our destination.
And I know that might seem like an odd analogy, but when we ask you to sit here, and this goes back to the brutal honesty, because the defendant, Chad Daybell, is entitled to a fair trial, as is the state, we want to make sure that we have jurors that can say, you know what, I can sit here, I can weigh the evidence, I can be fair and impartial, and essentially I can land this plane. I can do what's being asked of me. And so as we go through these questions too, we want you thinking of that. Can you keep an open mind and weigh the evidence and give it the weight that it's due? Because that would be your job as the jurors here. So I have a little boy, and in the mornings when he wakes up, if I ask him, what do you want for breakfast? 9 times out of 10, it's cheesy eggs. But his cheesy eggs are made a certain way. We have to do the eggs, we have the cheese, we have the milk, and we have the salt and pepper. And honestly, he likes extra cheese. So that's his recipe for the cheesy eggs that he wants me to make. And if I vary it, he's not necessarily happy. But do any of you have that experience where, whether it's a kid or someone in your life, there's some kind of a recipe that they like made just a certain way? That's just how they like it. And Juror 1004, have you had that experience?
Definitely similar with having 3 kids now and they're getting older, but yeah, my 3-year-old, she'll eat just about anything, but she's very particular about certain things. So yeah, I can relate.
And Juror 909, how about you?
Mainly with kids, but I don't know that I ever had anybody that was super specific. It was either I don't like it or do like it.
Or I like it. And if you're around someone like that and you're given this recipe, I think sometimes it's easy to say, you know, if I changed it this way, if I added this, or if I took this out, or I made it just a little bit different, it would make more sense, or I would like it better. When you're sitting here today, and the judge did give you one jury instruction today, if you're selected, you're going to hear a lot of jury instructions as you go through this. And some of those jury instructions are also going to be instructions that contain the elements of the crime. So kind of like a recipe, the judge is going to lay out, the state has to prove these specific things. The state doesn't have to prove these other things, and the state has to prove all of them. And sometimes it's easy to look at those and think, well, this doesn't make a lot of sense. Why don't they have to prove this? Or maybe they shouldn't have to prove this. But we have to make sure that you can follow that recipe or that jury instruction as given by the judge. Does anyone have concerns that you wouldn't be able to follow the instructions given by the judge, or that you'd be tempted to modify it? Anyone have that concern at all? Okay, I don't see anyone saying they have that concern. So with those, when we talk about the recipe and the instructions, as I said, the judge will lay out the elements. And sometimes it might not require an ingredient or an element that you think we should have to prove. When you're dealing with first degree, you would get a jury instruction and it'll come from the court, but it will essentially talk about an individual had to be part of causing the death. But one of the elements isn't going to be that we have to prove the actual cause. So essentially we have to prove that they were part of it or that they committed the murder, but we don't have to prove how they went about it. Does anyone have concerns with that, with following the court's instruction on that? So if the state was able to meet the burden of proving that they did it or they were part of it, of the murder, would anyone have concerns if the state didn't prove the actual cause of the murder, if that's not one of the ingredients? I don't see anyone saying yes to that. And again, you previously heard the judge give an instruction regarding conspiracy and talking about it being an agreement by 2 or more persons to commit a crime. So I'll tell you, I have some older brothers, and 2 of them were pretty close in age. And so my mom will tell stories about the 2 of them because they would get into shenanigans together. And the 2 of them, one of the things that they would do is the older brother and the younger brother would get together and they'd come up with a plan. And oftentimes the older brother wanted the younger one to carry it out first. So they came up with a plan to jump out of the barn door. So as part of this, they come up with the plan, they go into the barn together, they climb the stairs, and the younger brother jumps out. Well, he gets hurt. So the older brother doesn't follow. But they both had talked about going to do it. They both had the intention. So ultimately, they both were involved in that. So when we talk about a conspiracy and an agreement by 2 persons to commit a crime, you'll get instructions regarding the agreement and what qualifies as an agreement and what an agreement actually is. And again, that will come from the court. But it will talk about the only one person in that agreement has to do something that is referred to as an overt act. So only one person has to do some act to further that. Does anyone have a problem? Because let me back up a little bit. You were also instructed by the court that there are co-conspirators that you may hear about, and you're not to worry about what's going on with them. But what you will hear evidence is of some of the actions or the allegations that the state has, and you'll hear evidence regarding those actions of the other co-conspirators. Does anyone have a problem knowing there's an agreement and only one person has to do an act in furtherance? Does anyone have concerns that person A may not have done the act in furtherance of the conspiracy and person B did? Does anyone have a problem then essentially holding person A still accountable? So like the brothers plan, both of them climb up the stairs, but only one jumps out the window. But they both planned it. They both were going to do it. Anyone have concerns about that at all? Thank you so much for your time this morning. I have no further questions.
All right, thank you, Ms. Wade. Mr. Pryor, you can conduct voir dire for the defense.
Good morning, ladies and gentlemen. Always distracted. I don't know if that's something I need to do medicine for. I'm here today to ask you a number of questions. And I don't want you to infer from any of those questions that there's a right or wrong answer. What we're here today is just talk and get to know each other and sort of get feelings about how we feel about a variety of topics. And again, there isn't any right or wrong answer. But before we start that, I do want to ask you a question. And I brought this up with a couple of the other jury folks. Many years ago, when I was a much younger man and much skinnier, I was in college and I was having to do jury service, much like what you folks are doing. And the attorney at the time, and I remember this, and I bet maybe it was the reason I became a lawyer, I don't know, had an impact. Because the attorney stood there and said, is there anybody who just doesn't want to be here today? And I thought that was a very interesting question. And I didn't think long. And I raised my hand. Now, I'm not trying to dodge my responsibility and my civic responsibility to be a juror. That's not really what I was doing. Because I appreciate that. And we have a law enforcement officer who's sworn to uphold the law and to do his best to follow the rules. And yet I can tell by the distress of having to be here, and I can see it on his face, that there's concern. And so I really want all of you, and the state talks about brutally honest, and I'm going to touch on that a little bit later, but I need all of you to be honest with me. And you're not going to hurt my feelings. I can't speak for the folks over here, but I know that no one's going to take offense to that because this is a serious case and it's a complicated case. And we need all of your attention. We need it to be focused on this. And it's not going to be imputed to you that you're not doing your civic duty. And it's not going to be suggested that you aren't, faithful to our country or all of those things that are at least important to me, but important to all of us. That's not the case here. But in all seriousness, I guess we have to really be honest about that. I'm not going to use the words brutally. I find that a strange adjective to attach to a statement of honesty, but that's their issue, I guess. But again, I'm going to ask this. Is there anybody who just feels that what's going on in their personal life is so profound and so complicated, they just don't think they could, in all reality, do this very complicated job? Hold up your cards, please, if you feel that way. Nobody. Okay. We're here today, and you've heard the allegations from the judge. You've heard him what he's had to say about the charges that are against Mr. Daybell. Is there anybody here who at the present time, based on what the charges are alleged, believes that Mr. Daybell is guilty right now? At the present time that he's guilty right now. 1057? Okay, and 10-044. And I guess I'll inquire, 1057, is there any chance that you're going to be able to change your mind in that regard, or are you pretty firm in your belief at this point?
I will definitely weigh the evidence.
Okay, okay,
You asked if I felt that, and I answered correctly.
okay,
I answered honestly.
okay, okay. And 10-04, law enforcement officer, and I can understand that.
I definitely would want to weigh the evidence, would weigh disagreements.
Okay, all right, thank you. Is there anybody here who can't sit for long periods of time, other than me? Is there anybody who is unable to sit, or because of any kind of health concerns, you're not able to, okay, 922. You have some concerns about sitting for long periods of time?
I know I'm young, but I have had a kidney stone in the past. I'm already sitting here, wishing for a bathroom break, I'm not gonna lie. Sometimes it's just, health concerns, it's difficult.
Do we need to take, and I don't want to announce this, but do we need to take a break right now?
Not on my account only, but, if there's other people who need it.
Judge, do you think you want to take a short break?
I do, actually. Looking at the time, sometimes we lose track of how long these jurors have been captive before we get breaks and other court staffs. So it is late in the morning. Let's go ahead and take our mid-morning recess.
Judge, I'm joining them.
Okay, and we'll conclude then with additional defense for Dyer, but we'll go ahead and take a mid-morning recess at this time and try to come back in about 20 minutes.
All right, please.
Yes.
Thank you. Please be seated. Have the jurors brought in, please.
Yes, sir. All right, please.
Thank you. Please be seated. Okay, we're back on the record. We are in voir dire. Mr. Pryor was doing so for the defense. You can continue, Mr. Pryor. Thank you.
Ladies and gentlemen, I'll move on a little bit. Is there anybody in the jury pool today who knows any of the parties that are here today? Any of the attorneys? Number 10004.
Yes, sir. I'm familiar with Ingrid Beatty. I've worked cases with her again.
And would you just, without too much specific, identify which one you say is Ingrid Beatty?
He's the blonde.
And there's no doubt that the two of you know each other.
No, sir.
And the fact is you worked on cases with her.
That's correct.
And you're familiar with her.
Yes, sir.
And you discussed it. And the fact that you've worked on cases with her, is there even the slightest possibility that you would put more weight to anything she said as opposed to, let's say, me?
In all honesty, yes. She's a very good investigator and prosecutor, and yes.
Okay, so if you were to have me testify and, or not testify, excuse me, if I were to offer some evidence, Ms. Beatty was offering evidence here, and it would be, and it's human nature, you'd agree with that, right?
In truthfulness, yes, sir.
Yeah.
That would.
And in fact, you would give Ms. Beatty more weight and pursue that situation. Is that fair?
I think that'd be fair, sir.
Okay, okay. And thank you for your brutal honesty, I guess. I'd use a different word. I guess I'd say transparent. Brutal always sounds so difficult to me, but anyway, I'm going to move on a little bit, and thank you for that disclosure. I appreciate that. Part of this case, so we are going to see some pictures. Very, very graphic pictures. I want to tell you that I'm involved in this case. When I look at these pictures actually hurt my heart. Difficulty is this, is that although they hurt my heart, is it fair that when I look at these pictures, I assign those pictures to Mr. Daybell? Is there anybody, because they look at these pictures and then you have the same reaction that I have, that these pictures truly hurt my heart and it's painful? Is there anybody who's going to be able, who's going to say, these pictures hurt me so bad that I have to blame him regardless of what the evidence may show or otherwise? Is there anyone? So Juror number 791, is that your number?
Yes.
Okay. I you know, I see your reaction, like this to your facial. Are you trying to be strong, or is that something that you think is going to have an impact on
It's hard for me to say ahead of time. I would like to think that I will take all of the evidence and weigh them appropriately. I hold myself to a very high standard, and the nature of the case I would want to be very fair and impartial, not taking anything lightly. Due to the nature of the images that might be shown. Will probably be difficult. I can't say how I'll necessarily react to them, but I don't think I will let it impact my ability to judge.
And I appreciate you taking the time to talk about this, because you can understand and agree probably that looking at very graphic pictures can have an impact on it. But we need to be honest about that. I talked about that before. There's no right or wrong answer. This isn't a test that you get scored on. What we want you to do is to be able to look at the evidence as fairly and as impartially as possible. And when either of us, whether it's these folks over here to my right or on my side, provide you with some information or to show you some images, they're going to be painful and they're going to be graphic. But what has to happen is that you have to look beyond all of that and say, I'm going to take the value of those pictures and look at those to prove some point. But is there anybody who thinks it's fair that by automatically looking at the pictures that you should presume that Mr. Daybell is guilty because you looked at very unsettling and disturbing pictures? Is there anybody? Juror number 1048, what are your thoughts on this? As far as the ability to view graphic pictures, look at those things.
I don't feel like I have any concerns. I feel like I'll be able to do what I'm asked to do.
Okay.
I've been in a line of work where I've had to learn to compartmentalize things, and so I think I'm capable of doing that.
Okay. And I went to you because I'm going off of my memory. Hopefully it's still relatively intact as I get older. But my recollection, if I recall, is that you're the juvenile corrections person. Is that correct?
That's correct.
Okay. And I would imagine you do have to deal with those things, and you have to be able to compartmentalize and separate your feelings about certain things and look at things in the big picture. Is that fair?
That's fair, yes.
Okay, I'm going to switch gears a little bit, just a little bit. And I want to talk a little bit about bias, how we judge and view bias. And I think what I'm going to do, and please forgive me, officer, I don't mean to keep picking on you. And I appreciate your being very honest about that. But when my recollection of yours, and correct me if I'm wrong, is that you were a traffic officer, is that right?
I'm a patrol officer.
Patrol officer, I used the wrong term, I'm sorry. Now, as a patrol officer, while you're driving down the road and you find someone who's breaking the law, like speeding, and you pull them over, okay? Now, I have a difficulty is that in my prior life as a lawyer, when I got pulled over by a police officer, I had a habit of just saying, yes, I was speeding. And then they would ridicule me with the particular law enforcement agency that I dealt with. They said, you know, you're a lawyer. Why are you admitting the truth? And then I said, well, it's because I was speeding. And I was being very honest about things like that. Is that your usual experience that when you pull people over for speeding, they immediately acknowledge that they were breaking the law?
I'd say it happens more than not, but there's definitely some that
Try to get out of it.
try to get out. Yes, sir.
And there's various reasons people try to get out of things, right? And there's various reasons that people may not be particularly honest about things, right?
I would agree with that, yes.
And then one of those reasons could be they have an agenda.
That'd be fair to say, yes.
Okay, and that doesn't just apply to regular citizens, it applies to everybody, right?
I would agree.
It applies to doctors. Police officers can have an agenda, they can have a desire that a particular case goes a certain way. Do you do that?
I definitely have biases, everybody does. I'm not gonna say I don't. I definitely, in the interest of being professional, I remove those things. I can maybe assume a situation is gonna go a certain way or assume something happened, but I also know that if I'm gonna arrest somebody or if I'm gonna write somebody a ticket, I need to be able to prove beyond reasonable doubt that in fact, whatever the violation or crime that we're dealing with happened.
And you would agree with me that if a like in your, I'll just stick with your profession, I'll get to some of these other folks, but in your profession, if someone has a bias, that's a troubling issue, isn't it?
It can be if they let that interfere with making decisions, you know, in a particular case or something like that. Everybody, I would agree, has biases. You know, everyone has different opinions about a book they read, things like that. It's when it becomes an issue is when that, those internal feelings, internal thoughts based on whatever experience you've had in life, like that, when you start to allow those to actually dictate your decisions, that's when we would have an issue, especially in my profession.
Or you make a predetermined decision that this is what the results you want. That's concerning as well.
It could be, yes.
And that should never happen in law enforcement, should it?
When it comes down to making actual charges and arrests, no. There's times where sometimes based on experience, there can be certain perceptions from a situation that, based on training and experience, can lead me in a direction of either proving something or disproving that an event occurred or details of it occurred or not.
Okay. But the reality is that you shouldn't have that tunnel vision. You should look at the whole picture rather than trying to pursue an agenda. Is that fair?
I would agree, yes.
Okay. It's inappropriate for someone in a position of authority to inject their opinion and then pursue a matter because that's the result that they desire. Do you agree with that?
I think it's solely on that, yes, sir.
And that's bias, right?
Yes, sir.
Okay. Thank you very much for your answer. Now, the prosecuting attorney talked a little bit about conspiracy. Is there anybody here who doesn't know what the term agreement means? Please raise your hand if you know what an agreement is. Okay. Please raise your hand if you don't know what the term agreed means. A-G-R-E-E-D. Does everybody know what agreed means? Okay. I'm going to give you a little hypothetical. I'm going to inject one of you in this hypothetical, okay? And I haven't picked on Juror 951, so we're going to pick on you a little bit. Is that okay? And if it's too much, tell me, please, okay? This isn't to put you on the spot. We know each other, let's assume we know each other, and I go up to you and I say, you know, Juror 951, it's a beautiful day out today. I'm going fishing today. Okay? And then I go off and go on a fishing trip. And then suddenly I look over across the pond and you're there fishing. And I didn't know it. Do you believe that's an agreement to go fishing together?
Yes and no.
Okay. And why do you say that?
Yes, you had mentioned that you were going to go fishing.
Okay.
but I've never like agreed to go fishing with you.
Okay.
And so if you were to be there fishing and I just happened to come along and I start fishing across the pond, that wasn't like an agreement to go together.
Right. So you, in that instance, you would say there is no agreement. Okay, and juror number 922, you had an interesting, you nodded. And I guess I'd like to.
I appreciated your 951's answer of both yes and no, but
Okay.
recognizing that, I don't know, that kind of social situation is awkward in one part, and to have an agreement, you really need to talk about it beforehand.
Right. And when you say you need to talk about it, does it have to be laid out specifically?
No, I don't believe so.
Okay. And what are your thoughts on that, juror number side? Limited that. 752.
There wasn't an agreement.
Okay.
They just showed up at the same time, for instance, but yeah, nothing was agreed.
Okay. And let's say as a result of the fishing, let's go a step further with this. As a result of this wonderful fishing trip that I went on, I look upon the port across the pond and the other person fishing, and we're going to let you off the hook today. Sort of, that's a terrible expression, but we're going to let you off the hook today, juror 951, and we're going to say it was somebody else, okay? And let's say that as a result of both of us being out there fishing at the same time, I'm not catching anything. But boy, the other person across the pond has a stringer full of like 10 trout. And juror number 1057, the limit on trout that day was only 6. And unfortunately, that person was breaking the law. And along comes the fish and game officer. And this fish and game officer says, you broke the law and I'm giving you a citation. Okay? In that situation, am I responsible for a citation as well because I'm fishing on the other side of the pond?
I do not think so.
Okay. Juror 1048, should I be getting a citation because I was fishing on the other side of the pond?
No, if you didn't reach your limit or exceed your limit, then no.
Well, what about just the fact that maybe we were both there fishing together and there may have been, whether there's an agreement or not, does that make me guilty?
Judge, may we approach?
Yes.
Now whoops, I'm sorry. Oh my gosh, well, maybe we should start.
All rise. Court's again in session.
Okay, if you see it.
I tried to start without you.
All right, just back on the record here, the court will note for the record, we had a sidebar concerning the scope of voir dire. The court generally does disfavor hypotheticals, and I've notified counsel of that, considering Idaho Criminal Law 24B. So, Mr. Pryor, I'll allow you to continue with your voir dire, but please refrain from further hypotheticals at this point.
I'm going to switch gears a little bit and try to avoid the hypotheticals. I think there's enough fishing stories. I need to know your feelings on how you would evaluate truthfulness, bias, whether people are telling the truth. I'm going to go back to my police officer. And how do you gauge, officer, whether someone's being truthful?
There's many different ways. There's body language, there's eye contact or lack thereof. There's also, through the investigation, whether an individual's statements are adding up with the evidence I have, corroborating statements, or other statements that disprove what they're saying. And there's lots of different ways you can detect lies or, pursue the truth, either do.
And as part of your occupation, you actually carry camera and recorder, is that right?
That's correct.
Is that a standard practice?
For our department, it is, yes.
Okay, and it's a good idea to record when you're investigating a crime. Do you agree with me?
It is.
Okay. Okay. And are there instances where you would not record something if you're involved in a crime investigation?
Per my department's policies, it's if we're interviewing suspects, victims, or pretty much any contact with the public, we record. So
That's okay, thank you. So if we move on to the issue of trying to gauge how someone's being truthful or not being truthful. There are various reasons that people are untruthful, okay? And in line with trying to give everybody an opportunity to talk, we'll go to 909 because I haven't done anything with you yet. What sort of instances do you see where people tend to be untruthful?
When they have done something wrong.
Okay.
So
right off the bat, if they're trying to get away with something, they tend to be untruthful. Would that be fair? Yes. Okay. Are there other reasons people are untruthful?
sure, little white lies.
Okay, little white lies, that would be to a spouse or something.
Sure.
Okay, or it could be bigger white lies. Let's say one of the people in the relationship is having an affair. Do you think people lie when they're in an affair with somebody else? Yes. Okay. And I'm going to go to 922 and I'm going to work my way through. Do you think that people tend to be untruthful when they're involved in affairs or unrelated relationships they shouldn't be in?
Yes, of course.
Okay. And how do you feel about that?
About the lie itself?
Well, about the fact that maybe someone is trying to cover up an affair. Would you think that's human nature to do that if you're engaged in that conduct?
I'd say it most likely comes from a place of shame and guilt, at least in most instances.
Okay.
And I think we ought to be opposed to those feelings.
Okay. And what are your thoughts on that number, jury number 1048?
Did you restate the question?
Well, affairs, in terms of truthfulness. Is it a tendency for people to be truthful when they're involved in an affair?
I would say it's probably a tendency to be untruthful if they're involved in an affair.
And it's a way to sort of, like juror number 922 said, just hide your shame, or there may be other reasons as well, right?
I would agree.
But it's not uncommon that if someone's trying to hide a relationship of some kind, in your eyes, they would likely be untruthful about that, trying to hide that relationship.
I would say that's the case, yes.
Okay, all right, okay. Thank you very much about that. Your thoughts on that, juror number 951?
From previous line of work, I would say that you restate that question?
Well, what are your feelings about if someone's involved in an affair? Is that something that you tend to see where they would be truthful, untruthful, or would they just basically have asked, they would say, oh yeah, I'm doing that?
I would say that when an affair is occurring, yes, they're going to be untruthful about it because we try to hide what's going on.
Okay, okay. Okay, all right. Folks, I want to thank you for your time. I appreciate it. I know this is the most comfortable thing to do, but it's necessary and it's important. And I think both of us, both sides, folks to my right here, the prosecuting attorney's office and myself, we're striving along with the judge to try to get an idea of what your thoughts are and beliefs are. And again, folks, there's no right or wrong answer. All of you have a right to an opinion, and I think both sides are going to respect, and I know the court's going to respect your opinion. So I want to thank you for what you've done today and having to go through this. I hope it wasn't too terribly uncomfortable. Thank you.
All right, thank you, Mr. Pryor. That will conclude the group session of this voir dire examination. At this time, we're going to move on with individual questioning on different topics for certain jurors, and we'll have each of you return individually. So we'll start off smallest number to largest. And so if juror 752, you would remain seated, please, and the remaining jurors, if you'd all step out with the bailiff.
All right, great.
Thank you. Please be seated. All right, for juror 752, upon review of the questionnaire, I think the only topic that we need to address in further voir dire would relate to questions regarding the death penalty. Does the state agree or have any further question on bias or hardship?
I don't think so. No. No, Your Honor.
All right, any further questioning before we get on to the death penalty questions with this juror, Mr. Pryor?
Judge, no. I guess I just want to clarify a couple of things.
Okay, if you go ahead and make sure your mic's on, Mr. Pryor, we'll allow you some additional voir dire on the hardship.
Now, sir, you mentioned that there may be an opportunity for them to sort of cover your responsibility as the chief financial officer. Do you have an assistant or someone who works underneath you who perform the same duties?
So I have a controller underneath me that can do probably 70% of the work that I do. My only concern is it gets sequestered because I plan on working in the evenings, early mornings, weekends and stuff to cover up the remaining things. So.
And that was what my concern is because you mentioned that your hardship in the beginning, your evaluation, I'm going off of memory once again, but at the very end, and do you have a copy of your evaluation or your questionnaire? Excuse me.
Yes, I do.
And if you return to the bottom portion, almost the very last page of your questionnaire, there's a comment there that talks about the fact that, please don't allow me to put words in your mouth, but seems to suggest to me that you intend to work while you were on your free time during this trial. Is that what I'm hearing?
If there's, like say we leave at 3:30 in the afternoon, I'm planning to work the remaining part of the evening.
And when you say the remaining part of the evening, what do you refer to?
So probably till 7 o'clock.
Okay.
I'm used to working long hours, so
okay. Is that your standard practice you're accustomed to working very, very long hours anyway?
It just depends on situations. If it's not been called in, if we're going through a sale of the company a few years ago, it requires me to work significant amount of hours.
Well, I understand it's significant, and I'm not trying to argue with you. I'm trying to get a feel for whether or not I'm comfortable with you working, 5, 6, 7 hours after sitting in front of a jury and absorbing all of this information. This is not a reflection on you. Please don't take it. Please don't take it. What I have a concern about is that whether you're going to be able to put the necessary attention and focus. You have a significant job, very, time-consuming job. It's going to require a lot of attention. This is not just any run-of-the-mill job like me or anybody else. This is a serious position. And it requires a significant amount of time and effort to perform your job. Do you agree with that?
That is correct.
And what I have concerns about is that at the end of a 5, 6, 7 hour day listening to evidence, you're not going to have that downtime. You're not going to have that release to be able to absorb and maybe rest your mind, so that instead what you're going to do is you're going to go and work for, at least from what I'm hearing, 5 or 6 more hours on your job responsibilities and try to keep things afloat. Is that what I'm hearing?
There will be days like that.
Is it going to be every day?
I can't say it'll be every day, but there will be days where there's certain things come up that I would need to handle. So to me, my only concern is if I got sequestered where I wouldn't be able to have access to internet or anything else. And that goes on for a length period, yes, that would create some concerns.
And that's going to cause some concern in terms of your employment.
I mean, they wouldn't terminate me, but like I say, there's decision making that gets done that I would need to be part of, that I wouldn't be able to be part of.
But are you, the judge has purposely set a schedule for us from like 8:30 to 3:30 with time for some lunch to be able to do that. What I have a concern about is the court specifically set a short time, and I don't want to read into what the court suggested. It's not like for you to do that, but I would imagine the reason he's doing that is because after 5 or 6 hours of engaging in this sort of position to be a juror, you're going to need some time to recuperate from that. It doesn't sound like you're going to do that. It sounds like you're going to work.
I mean, like I say, we all have responsibilities. Even when I come home in the evening, I got to take care of kids. I'm used to doing this. Like I say, I don't want to say this is not possible. It really is possible to do multiple jobs. And like I say, to do this, I need to still work a couple of hours in the evening. This is what I'm accustomed to.
Okay, and you don't think that that's going to have any kind of an impact on your ability to effectively listen and do the job as a juror for 10 weeks?
I don't believe so. Like I said, my only concern is if we get sequestered, and that's a piece I don't have control of.
And if you do get sequestered, that is a significant concern. That would
correct, because I don't know how long that will last.
I'm sorry, I apologize.
Yeah, a question and then answer.
Go ahead, sir. I'm sorry.
Yeah, no, that's my only concern. If I get sequestered, if it was for a week or 2 weeks, that would be concerning.
And at that point, it becomes a hardship. Would that be fair?
I would say yes.
And sir, don't take this as a personal affront. You can appreciate that I have a concern that you're going to be doing 2 jobs at a time when we're dealing with a case of significance. So, Judge, I'm going to move the cause in this particular case. I have a concern for his.
A response from the state?
Bigley, we would object to that motion. We believe that the juror has continually expressed his understanding of the potential risks or any potential hardship serving as a juror. But he also understands that he has plans and he practice he can serve. So I haven't heard this juror say that he feels like it will actually be a hardship. He just has expressed concern. So at this point, we don't think that there's a cause to excuse this juror.
Okay, I'll just have a follow-up inquiry briefly here, Juror 752. There is a substantial likelihood of a time of sequestration without making any promises. That could be a week. There's potential it could be longer though. And when you consider that, do you still feel like you're able to give your undivided attention to this case, even should a sequestration period take place?
I would say, depending when the week happened, if it was over a month-end week, it would cause concerns for me because like I said, we wouldn't be able to close our financials, which we need to report at that time.
If that were to happen with bad timing, would someone else be able to assist in your employment responsibilities in your absence?
They, like I said, they would, but they wouldn't be able to complete the full job. Unfortunately, like I have a controller that's been around about 4 or 5 months. She's not at the point where she can completely prepare the financials.
All right, but you're telling me you would be able to, regardless of your work commitments here, be committed and able to fully pay attention and consider the evidence in this case?
That is correct.
All right, I'm going to overrule the objection as to 752 in terms of expression of a hardship based on his responses. And so the next matter the court then is going to address with you, Juror 752, is it in relation to that part of your questionnaire that's titled Attitudes Regarding the Death Penalty. Do you recall last week when you answered your questionnaire, thinking about and answering questions concerning the death penalty? Okay, are the answers you provided in that questionnaire still accurate and reflect the way you feel as you sit here today?
I do agree.
Okay. You indicated in your questionnaire you support the death penalty when you were given the option of yes or no, support or oppose. You said support. Do you still agree with that stance?
I do.
You also made a choice when given options about what most accurately represents the way you feel, and you said option C, which is, quote, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Do you still think that accurately represents how you feel about it?
Yes, sir.
Okay. Let me just ask an additional question there. If you are in favor of the death penalty, then do you believe the death penalty is appropriate or should be considered in every case where a murder has been committed?
When it's first degree murder, I do believe it should be considered.
Okay, and if the court were to give you instructions then about the death penalty, would you follow those instructions?
Yes.
If the court included instructions for some reason that you were not to consider the death penalty or instructing you that there are options besides the death penalty, would you fully and fairly consider those options as well?
I will.
All right.
Yes.
So given your views then, is there any reason for me to think your views would prevent or substantially impair your ability to serve as a juror in this case in accordance with the court's instructions if you receive those about the death penalty?
No, there should be no concerns that I would follow.
All right, thank you. That concludes my inquiry on that topic. Does the state have any more dire on the issue of the death penalty?
We do not, Your Honor.
Nothing further, Judge. Thank you.
All right, thank you. That'll conclude your individual regard, Juror 752. You'll be escorted back to the jury room. We'll bring another juror in and we'll get through the rest and then you'll receive further instructions. All right, thank you for returning. This is Juror 791. We've got some additional voir dire I think we need to conduct as it relates to potential bias, and that would be due to information this juror has about the case from previous media. Some expression of concerns also about guilt. So the court wants to start there with bias questions. If the state would like to conduct any voir dire, I'll allow that, and then I'll allow the defense.
Morning. Morning. So I just wanted to ask you a few questions about some of the media exposure that you had in this case. In your questionnaire, you referenced some news reports and also some documentaries. Do you recall which documentaries that you watched?
The two that come to mind, one was from I think it's ABC 2020. And the other one was a Netflix documentary. I watched it once when it came out. I can't recall the title, but it was specifically about Lori.
And that's okay. On one of the questions in the questionnaire that you filled out, at the top of page 15, there was a question: could your knowledge of Chad Daybell prevent you from acting impartially in this case? One of the things that the judge is going to instruct you during this trial is that Mr. Daybell is innocent until the state meets its burden of proof. And the state would meet its burden of proof by introducing evidence during the trial. Nothing that you've heard thus far is evidence. Would you agree?
Correct.
Okay. Now, in answer to this question about your knowledge of Mr. Daybell, I believe that you were concerned that what you've heard so far would impact your ability to be impartial in this case. Are you concerned about that?
I've been going back and forth on it. Trying to gather my thoughts here.
Okay.
I feel like with some of my answers, and I kind of feeling I was probably contradicting myself unintentionally. I feel I have a fairly good grasp of being able to compartmentalize that I would not allow like the stuff that I've heard in the past, which has been quite a while, to affect my judgment.
Yeah. Okay, fair enough. In one question toward the bottom of page 15, you had indicated that even knowing that news reports and documentaries are biased, the evidence points to guilt. Do you still believe that up to this point?
I think I was trying to answer it, my mindset separate from me. So it was more the mindset of documentaries, or mostly documentaries. Especially the Netflix, if I have a predisposition of viewing the defendant as guilty. So it's more that I am aware and I acknowledge that what I was watching already had the preconceived notion of guilt. I don't think I put that across very well.
No, that's completely fair, and I really appreciate your honesty. I appreciate your honesty today and in your questionnaire. Would it be fair to say that this is something you're still wrestling with?
I would want to say no. I don't know, parts of me disagree with that. Because again, with the compartmentalizing, viewing the evidence as it is, and again, not taking what this is about lightly. I don't want to presume guilt where there is none. I wouldn't want to subject any innocent person or anyone to anything like that.
Of course. And just one last question. Toward the bottom of the questionnaire on page 19, you had indicated that you had formed an opinion of Mr. Daybell's guilt and that you could possibly set it aside. Has that opinion changed today, as of today?
No.
Okay. Your Honor, I would move to excuse this juror for the exposure to the media that she's already had.
All right, so request from the state for excusal for bias. Mr. Pryor, response?
Judge, I could just want your, just a couple of questions.
You may.
And I appreciate your being honest. What I'm seeing is that you're struggling with this issue and you're not sure really how you feel. Would that be fair?
That would probably be fair.
If you're struggling with this, I think that's close. There's no wrong or right answer. What we're trying to accomplish is people who are, pretty certain about what they are. If you're struggling with things, we all struggle with things. This is a big deal. So I don't want you to feel like we're beating up on you or being disrespectful to you in any way. In fact, I appreciate the honesty and how straightforward you've been about answering this. Judge, I think I concur with the state. I just have concerns about something that she's just struggling.
Very well. I've considered the responses in the questionnaire also. Juror 791. Absolutely nothing wrong with being interested in cases, following them, knowing about them. As you have mentioned here both today and in filling out your questionnaire, sometimes they portray things in a way that will cause people to form opinions. I do concur that I think the opinion's been formed here. So based on the responses, I am going to extend the state's motion to strike for cause for this juror based on bias. So thank you so much for your responses today, for taking the time to complete your questionnaire, for returning back, and the court gives you sincere thanks. Please drop your questionnaire with the bailiff on your way out. All right, we'll next have juror 823.
Did I had 823 is excused? Did I miss?
Oh, I may have. Oh, this is 823. I apologize. 823 was our juror who ran late, but I think is going to be returning maybe tomorrow. We'll talk to the jury commissioner and I'll clarify that with counsel. So 909. All right, juror 909 has returned some indication in the questionnaire of knowledge of the case. So this is the time, juror 909, we want to discuss what you may know about the facts of this case and how that may impact your ability to be impartial. I'll ask the state at this time if you'd like to inquire and voir dire on that issue.
Thank you. Juror 909. Looking through your questionnaire, it looks like you know a fair amount about this case. Is that accurate?
Not necessarily this particular case, but I knew about the other case that this deals with a little.
And are you referring to the case of Lori Vallow?
Yes.
And did you follow that trial?
Not super closely, but there was enough talk about that I heard stuff. So I heard something about the trial. I knew the trial was going on. I knew about conviction. I knew that.
And with what you did know about that, do you think that could in any way shape your opinion about the presumption of innocence for this defendant going into the trial?
I think it's possible, yeah.
I think in your questionnaire, when it asked if any of your possible exposure to news reporting or the city around this case caused you to form an opinion, you said maybe, and when asked if you could put it out of your mind, you said maybe I could try to be impartial.
I would like to think I could be impartial, but I can't help but wonder if evidence from the defensive side, from the side of the defense would have to sway me, and I know that that's not. I'm not sure that I can say that he wouldn't have to do something.
Sure.
To sway me.
So, and there's no right or wrong answers. We appreciate your honesty. So, Your Honor, based on that response, the state would move to excuse juror 909. Appreciate your honesty.
Response from the defense.
Judge, I would move as well. I appreciate his honesty. I appreciate it's straightforward about your responses, but this situation.
All right, juror 909, I've considered your responses to the questionnaire also. I do think that for you in particular for this case, not the best match as a juror since you have knowledge of the corresponding case, which has likely influenced your opinion of the defendant in a way that would be unfair. So nothing personal again. This is just the information we're going through with each juror to ensure a fair and impartial jury in this case. So thank you very much for filling out your questionnaire, taking your time to come back today. You're excused from your jury service, and please drop that questionnaire with the bailiff. Next juror will be 922. All right, thank you for returning juror 922. Just reviewing the questionnaire here, and I don't believe there was any expression of prior case knowledge here, nor concern necessarily about hardship. So as I understand it, with this particular juror, we would be reviewing questions relating to the death penalty. Does the state have any further report other than that topic?
Judge, we actually do have one small question related to hardship.
Go ahead and start that then, Mr. Whitson.
Thank you, Your Honor. Sir, do you happen to have a questioner with you?
I do.
I might just invite you to go to page 20 of the question. Anyway, Bill, before I ask the question, you did indicate that you did not feel necessarily a specific hardship if you were to be injured. Is that right?
That's correct.
Page 20, question 2, you indicated that perhaps you have some anxiety and that you would need legs so you can pay attention.
That's correct.
Do you feel comfortable just explaining that a little bit more?
Sure, and it came up earlier as well in regards to health issues. Both, I think physically and mentally, I prefer to have frequent breaks in order to process information better and so on. I think that I can perform just fine. I've done so academically, at least in my life, but I wanted to also recognize that I have those, I wouldn't even say shortcomings, just challenges that I face.
When you say frequent breaks, do you have any idea what that might require for you? Say that in the worst scenario versus the best scenario.
I think usually every few hours is fine. I know it's hard to judge simply because I have yet to be in a situation like this, and I can't necessarily, comprehensively predict how I might react to what is invariably difficult information. But I think that the structure of at least what I've experienced so far is manageable.
So then just as a final question, in your estimation, as you said there today, you do believe that even though there'll be perhaps even distressing photos or graphic things that may cause some additional anxiety, you do feel like you can manage that and work it through that SERB if you're chosen. Is that correct?
That's correct.
Thank you for answering the questions. Judge, I don't have any more questions.
No, Judge. Okay, thank you. All right, so Juror 922, the next topic we want to go through with you relates to the section of your questionnaire that, and do you have a copy of your questionnaire there?
Yes.
All right, we're on page 12, and that's the section 5 of the questionnaire, attitudes regarding the death penalty. Do you recall going through these questions last week and answering them?
I do, but may I make an amendment? Is that?
Yeah, I saw, I think I know where you're going with this, but tell me what you intend to change or correct on your responses, if you would.
It was more so at the time I was operating with the understanding that process was sort of one fell swoop. And you may correct me if this is incorrect, but it seems that it is the first responsibility of the jury to determine a guilty or not guilty verdict based on the evidence, and then to decide the charges.
In general terms, I think you're accurately tracking the legal process that would occur in this case, yes. Okay, and while we're talking about that, well, let me first let you know that in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And remember that any penalty you're considering could be considered as if it is absolute and would be carried out in the case. So with that in mind, a few questions. I did want to seek a correction here. You stated on page 12 you oppose the death penalty, is that correct?
Yes.
Okay, and you've made some other comments we can talk about in a moment. On page 13, you circled under part 6 and option A, and I wondered if that is the one you intended to mark. That's the option that says, if a person is convicted of murder and the death penalty is requested, I will always vote to impose it regardless of the facts, law, and instructions given in the case.
I would say that's correct, yes.
Okay, I'm wanting to make sure we're tracking on impose versus oppose. So support or oppose the death penalty, in other words, for or against it, you said oppose, and you made some statements. That circle A is to always impose it, would be to give someone the death penalty.
I see where you're going now, and I did indeed circle the wrong option, just based off of an oversight in wording.
Okay, and I understand where that occurred, and again, I'm not trying to influence or have you change that. It's just a diametrically opposed view there. Would you do me the favor of reading through these options again under part 6? And if A is not what you intended, let me know which option you believe most accurately represents your feelings. And if you need to take a moment to do that, please don't feel rushed.
Certainly, thank you. I believe F would be accurate. That is to say, I'm strongly opposed to the death penalty, and I would have a difficult time voting to impose it. Yes, voting to impose it, regardless of the facts, law, instructions in the case.
Okay, I appreciate you making that correction on your choices there. So let me go back through some additional questions then. You stated that your views on the death penalty would not impair your ability to view the facts of the case impartially. Do you still believe that? Would you view the facts here impartially?
I do.
Okay. Do you feel, you next checked the box, yes. Do you feel your views on the death penalty would prevent or impair your ability to return a verdict of guilty on first-degree murder against the defendant, even if the state proved it beyond a reasonable doubt? So the question again, to summarize, would your views impair your ability to return a guilty verdict here?
At the time, I believe so. I believe, at least upon further reflection, I'd say, knowing that there are sort of two concurrent processes, I believe it's entirely possible that I might find a person guilty or not guilty based solely on the evidence of the case. But I would still be stubborn or staunch in regards to what I believe is appropriate punishment under those circumstances.
Okay. So moving on then, if you were to find or determine and vote for guilt, and after that, the court gave you instructions requiring you to next consider the death penalty, would you refuse to follow those instructions or be opposed to those instructions?
I believe I could follow those instructions fairly, but I also still feel that my moral position is more sort of irrelevant to the facts of the case, that it applies in all circumstances, and so it would be difficult to reconcile that with the consideration of the case at hand.
Okay, so given your feelings then, even if you didn't morally agree with it or want to do it, if I gave you instructions that the law said you had to consider it, would you follow the instructions and allow those instructions to supersede your own personal views on this?
I would, especially considering that I would be just one among a group of jurors. I would defer to the sort of knowledge and expertise and conclusions of the group over my own stubbornly held beliefs.
Okay, so what you're not telling me is that you would absolutely refuse to follow an instruction if it required you to consider the death penalty?
I would consider it, yes.
Okay, thank you for your responses. That will conclude the court's voir dire on that issue on jurors 922. Does the state have questions?
We do, Your Honor.
Go ahead.
Sir, we certainly appreciate your candor, and certainly you're right to have the position. Although the response you just gave the court does raise a bit of a tangential concern. You said that you, in your deliberation, if the court were to instruct you to consider the death penalty, that you would defer to the other jurors. If in fact, part of the court's instructions are that any verdict be unanimous amongst all the jurors, and you were instructed that you needed to come up with your own verdict, taking the influence and considering the perspectives from the other jurors, but that you needed to make your own decision. Is that something that you still feel like you could do? Could you make your own decision, follow an instruction, and if actually appropriate, impose the death?
I believe I could. I believe it would also be, of course, strongly influenced invariably by the beliefs I hold now, but I believe I could.
When you say strongly influenced by the beliefs you hold now, perhaps could you flesh that out a bit more? Could you explain that some more?
Sure. I feel opposed to the death penalty in all cases, and so it is difficult for me to imagine trying to put myself in the shoes of someone who would consider it fairly to say that there are circumstances where the death penalty ought to be applied.
Is it fair to say then you have some doubt, even though you would be willing, you would have some doubt that you could actually do that? You could actually set that aside and consider instruction. Is that fair?
I think if I'm being fair and honest with myself, yes.
Thank you, sir. Your Honor, based on this, and I do appreciate the juror's candor and his honesty, I think he's going to be very honest. But I do also think that he has a very strong opposition to the death penalty. He's included it multiple times in this questionnaire. It was that today. I think he's trying to listen to the court and potential instructions, but he just told us that he's not confident that he can actually set this aside. And I think based upon that, he ought to be excused for cause based on this issue, Judge.
All right, Mr. Pryor, I'll allow some voir dire on the topic first.
Sir, I heard it a little differently. I heard that you'd be able to follow the court's instructions. Is that correct?
I believe I could, yes.
Okay, regardless of what those instructions are, right?
Yes, and also with consideration that the instructions are or will be, in the case of a guilty verdict, to consider the death penalty.
And please don't allow me words in your mouth. Just let me walk through this. I think you correctly identified, and the court recognized that. You recognized the first part of the process is determine whether there is guilt or innocence. But once the guilt or innocence is determined, then let's assume that there's a guilty verdict. That's not to imply anything with Chad, but let's assume there is a guilty verdict. At that point, the next process is for you to weigh whether you would vote for life in prison or whether you would impose the death penalty. And what I'm hearing from you is that you, although you feel very strongly and you have strong convictions against the death penalty, you will still follow this court's instructions, and you will honestly and faithfully follow the court's instructions and consider both, even though you hold these strong feelings. Is that fair?
Yes.
Judge,
that's fair.
Thank you.
All right, the court's considered these responses from the juror. Thank you for your candor in discussing the topic. The court does not determine here that these responses result in a finding that this juror would be substantially impaired or prevented from performing their duties based on an indication that they will follow instructions given by the court despite a strong or very strong moral opposition or belief against the death penalty. So the court will overrule the request to strike from the state, and that will conclude the individual voir dire for juror 922. So the bailiff will take you back to the jury room. We'll get through the rest of our jurors and give you further instructions before you're released today. Thank you. Let's next talk to juror 951. All right, thank you for returning. Juror 951, we're going to conduct some individual questioning with you, beginning with some information that you have about this case or the facts. So starting there with the state, if we want to discuss potential bias, I think that's the only issue for the other topic we'll get to based on, I don't believe any representation would be a hardship. So the state can inquire on bias.
Thank you, Your Honor. Good afternoon. So in your questionnaire, you indicated that you've had some media exposure to this case.
Correct.
About how much media exposure do you think you had?
When the case had eventually first started, a lot. To be completely honest, 100% a lot. Once it died down for a little bit, my thoughts died down. But after I had started my job with IDOC, it had gotten brought up multiple times.
So you had some conversations at work about it?
Yes, not like me individually having a conversation, but like hearing others talk about it. And so you hear people talk, and then you have your own thoughts that conclude to your head.
Just out of curiosity, what were your thoughts at the time?
I am a very forward person, and so I'm the type of person that I want to know the facts, and I want to see evidence, and I want to know the whole picture before I put pieces together to come up with a solution or the answer.
Sure. So did you form an opinion about the case and who might have done what?
To be completely honest, I want to say I had.
And was that in regard to the defendant, or was that in regard to Lori Vallow?
It was more of Lori Vallow that I had more of an opinion and I had more of knowledge on than Mr. Daybell.
Okay. And do you understand that you'll be instructed that the defendant enjoys a presumption of innocence? That means that he gets to start this trial with a clean slate. Is that an instruction that you can follow?
Absolutely.
And you understand that as Mr. Daybell sits here today, he's presumed innocent?
Absolutely.
And do you understand that nothing that you've seen in the news or heard in the media is evidence?
Correct.
And do you understand that you can only base your decision in this case on the evidence by a testimony from witnesses and exhibits that you get during this trial?
100%.
Okay. I have no additional questions for this witness. Thank you, Your Honor.
All right, thank you, Ms. Beatty. Mr. Pryor?
Ma'am, you mentioned that you had 100% media exposure. Is that, I assume that's a lot of exposure.
I suppose correct, yeah.
You've watched Dateline?
When the case had eventually, or like first started, I was on top of it. I was very interested. Not only from my previous career, but I also have always had the thought of becoming some sort of law enforcement. So I am always to watch anything that has to do with the news.
So you're an inquisitive person, that be fair?
Correct.
You're curious.
Yes.
And is that curiosity going to be creating a problem if you were limited during this trial to not looking at any of those things and only considering what you're hearing? And you are literally going to have to block out all the social media, all of your friendships. You're going to have to tell them we can't talk about it. And there's no right or wrong answer. Everybody, we're all different personalities, right?
Correct.
I imagine we're two different personalities. But it's a difficult thing to block out. You mentioned that you work at IDOC and then people started talking about it. You had to make an effort to sort of block that out, right?
Absolutely.
And it's a distraction, right?
To a point.
Okay.
I think from my background with IDOC and with my background from events that have occurred in my life, I'm very capable of putting things to the side and keeping things, I can't really say hidden, but like to myself, not to like discuss anything to anyone.
So if I understand what you're saying is that you, and one of the other jurors mentioned it was the term compartmentalize. In other words, I have a position, I've made have a view of what happened here. Okay, and then please bear with me. I've made a determination based on what I've seen up so far that this is what I think went on. But even though I've made a decision ahead of time, and I've taken the time, and you're an inquisitive person, and I've looked into things, and I've made a decision in my mind. But in spite of the decision I made, I'm going to consider the other evidence before I make my final decision. Would that be fair?
100%.
Okay. So in other words, you do have an idea and a position, obviously with Lori Vallow, right?
Yes, but I would, in my thought, I see is I want to see the evidence. I want to see the whole story before I become assertive to.
Right. In other words, you sort of made you have an idea what your position is. You said, all right, I made a determination of where I stand on this thing, okay? But at that point, before I make that final decision, I want to see the rest of the evidence.
Correct.
I want to be able to look at things and say, is my initial instinct and my personal feeling about this case and what I really believe happened, before I jump into that compartment, I want to confirm it with the rest of the evidence. Even though I've made a decision, I'm not going to say absolutely until I'm able to make the determination that my instincts were correct. Is that fair?
100%.
Okay, Judge, I have nothing else, and I move for cause in this particular case.
Response from the state.
And Your Honor, I believe that this juror has indicated that she can set aside what she has heard. I also believe that she was pretty clear that her initial impressions in this case were largely based around Ms. Vallow. She indicated both sitting here today and in her questionnaire that she could set those aside and be fair and impartial. So the state would object to the motion to excuse this juror.
All right, I've considered the motion in this particular matter with this juror and the responses today, who's indicated a willingness to follow the court's instructions and consider the evidence and comporting with instructions already provided. I have not heard a opinion that I think rises to the level where I'm concerned there's been a shifting of the burden as we have with many other jurors here. So for those reasons, I am going to overrule the challenge at this stage and continue on with for dire of this particular juror. All right, at this time then, Juror 951, the next topic we're going to discuss is the section of your questionnaire that's entitled Attitudes Regarding the Death Penalty. Do you recall last week filling out your questionnaire and thinking about those questions and filling out those responses?
100%.
And do you still maintain the same answers that you previously put in your questionnaire?
Yes.
Okay. I will advise you in this case that it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty in this case. Remember, any penalty you're considering should be done as if it is absolute and carried out in this case. So with that in mind, I will first, just reviewing your questionnaire, see that you checked the box saying you would support the death penalty, and you also said you strongly agree with the death penalty. Is that your belief here today?
100%.
Okay. You were given a series of choices about what accurately represents the way you feel about it. You checked an option under 6B, and you said, I am strongly in favor of the death penalty and would have a difficult time voting against it, regardless of the facts, law, and instructions in the case. Do you recall selecting that option? Okay, so knowing that you support the death penalty, the next question I'm going to have, and it relates back to that answer, is do you believe that the death penalty should be considered or given in every case where a murder's been committed?
No.
All right, in your mind, when would it not be appropriate to be considered?
In my belief, it's more of trying to figure out the best words. For somebody to perform an act of murder, I believe that not only, like, to some degree, they should receive the death penalty, but then at some point, they should have the, like, life to imprisonment to where they have the, like, they have the thought process of what they did and what they have to suffer. And family members to the victim what they have to suffer. So it depends on the crime, or like it depends on the murder.
Okay. Going back to your option B, you circled here, you said you would have a difficult time voting against it, regardless of what the instructions were in the case. If you are given instructions, are you going to follow those instructions, or do you think your view on it would impair your ability to follow the instructions if the instructions, for example, said you are not to consider it in this case?
I will follow the instructions. I said earlier, and I will say it again, I'm more of evidence to be proven guilty, and that I guess that is the way I see it.
Okay, and if part of your duty as a juror is to not only determine guilt or innocence based on evidence, if then you are required to consider punishment in this case, and you're given specific instructions about how to do that, including options that may or may not result in the death penalty being imposed, will you follow those instructions?
Yes.
Okay, that will conclude the court's voir dire of this juror on that topic. I'll ask the state if they have any voir dire.
Thank you, Your Honor. So when the judge asked you about whether or not you would impose the death penalty in every murder, I believe you said it depends on the murder. Is that right?
Correct.
And by that, did you mean that you would consider the facts of an individual case before you decided whether you think the death penalty is appropriate?
100%.
So you would consider evidence that was perhaps presented in mitigation or to in favor of the defendant not getting the death penalty. You would consider evidence like that before you made a decision.
Yes.
And you would weigh that evidence, and you would weigh any evidence presented by the state to decide whether or not you would impose the death penalty.
Correct.
You would not necessarily impose the death penalty in every case. Is that what you're saying?
Yes.
I have no additional questions.
All right, thank you, Ms. Beatty. Mr. Pryor, you can inquire.
Ma'am, I'm just trying to clarify.
Can you have your microphone on?
Do now.
Thank you.
Thank you, Judge. I'm just trying to clarify some things, if you don't mind. Is it your position that at the present time, if there's a murder involved, your starting position is, listen, I'm going to impose the death penalty, but I'm going to look at all of the evidence before I make that decision. So in other words, is it your starting position that, all right, and I'm not trying to imply whether Chad did this or not. Your starting position to say, all right, I'm going to vote for the death penalty unless I see something that convinces me otherwise. Would that be fair?
Yes.
Okay. So your starting position is the death penalty, and you're going to place the burden on the defense attorney to show that Mr. Daybell or anybody else who's convicted of murder should not get the death penalty. Is that what you're suggesting?
Correct.
Oh, okay. All right, thank you, ma'am. And Judge, I'm going to move for cause again.
All right, there's been a motion to strike based on those responses. What's the state's response?
Your Honor, this juror has indicated that she leans toward the death penalty, just as other jurors have indicated that they lean against the death penalty. However, she's also clearly indicated that she would follow instructions given by the court. And thus, I believe that it would not be appropriate to strike or to excuse her at this time.
Judge, may I respond?
Yes, go ahead.
Judge, the concern I have, with all respect to this, the preset notion that this is what I'm going to do, and putting the burden upon the defense to say, it's now your burden to convince me otherwise. I don't think that's what's going on.
All right, well, I've considered the arguments here. I think there's a different analysis that comes into play than a innocence or guilt analysis and presumption of innocence in reviewing the standard applying to whether or not a juror may serve in a case where capital punishment is being sought by the state, and the standard the court's looking at is whether or not their views are so strong that it's going to substantially impair or prevent them from serving as a juror and following the court's instructions. This juror has indicated a willingness to follow the court's instructions despite the fact that they may be opposed to that in their personal beliefs, and with that stated willingness to follow the instructions, the court does not find that this rises to the level of a for-cause excusal. So I'll overrule the challenge from the defense, and Juror 951, we will return here shortly for further instructions once we conclude our additional individual voir dire. So 1004 will be up next. All right, thank you for returning for this individual voir dire, juror 1004. First topic I'd like to discuss with this juror before we get into other areas. There's been expression of hardship, which was challenged and overruled by the court. However, there's also some indication of potential bias here. And this juror has already expressed in the questionnaire as well as in response to questioning in voir dire today that may have formed an opinion. So I'll begin with the state. If the state would like to conduct any individual voir dire regarding bias, let's begin there.
Thank you, Your Honor. Juror 1004. Just a reminder, there's no wrong or right answers here. And just want you to be fully honest, and everybody here will respect whatever your answer is. Going over your questionnaire, could you turn to page 19? And it looks like you saw or heard some talk radio and some media. Do you recall which talk radio or media programs you saw?
Exactly what they were talking about. Just in the car listening to her at home. I know I believe you mentioned the part of the documentary that I've watched.
And do you ballpark, about when you saw that media or heard that media?
Year and a half, 2 years ago.
So is it fair to say you haven't recently kept up on the case?
I have not, especially once being aware that we potentially involved with this research or listening to the news about it.
So I want to go over a couple of your answers with you just to see where you're at. Under 10D, it says, to be honest, it doesn't look good, but I would want to get the facts before deciding. And then you say you could set aside or put out in your mind what you've read or heard and say the facts would drive my feelings of guilt or not.
Correct, yeah. Based on just the prior, knowledge I have from, like I already divulged as far as, media and whatnot. The honest answer is, yeah, my initial opinion is like, yeah, this isn't going to be good. But then I did want to clarify and follow that statement up with, yes, I apologize. Sorry, forgot you're typing up with me. How do you recently start?
And I do want to clarify, yeah.
Okay. And making, known that just because, and we kind of talked about this with the bias earlier, right? You hear something or have parts of the puzzle and start to form assumptions, things like that. Obviously, some kind of case like this where, and I mentioned earlier too, as far as, when the person, I'm going to charge them with a crime, I'm not charging based on, solely just what I think based on a few things. I need to have evidence and proof of that. So that's, in this case, where I decided handing down a decision one way or the other, I want to base that decision off of the facts presented, and all the details of the case, or which ones I'm sure I'm aware of at this point.
And your involvement in the criminal justice system, you're aware that this defendant has the right, a very, very important right to a presumption of innocence, meaning that every juror who sits on this juror needs to be able to give him a clean slate at the beginning. So if you were to be put on this this jury, can you say without hesitation, with full commitment, you can set aside everything you've heard about him and only base your decision on the facts that are presented in this courtroom?
I would like to say that I could, but in all honesty, I think that'd be difficult. Don't be truthful, yes.
That's what we want. Thank you for being truthful. One moment, Your Honor. Your Honor, we're grateful for this juror's honesty. Based on his answers, we think we would need to move to excuse this juror cause.
All right, from the defense.
And officer, I really appreciate your honesty as well. This would get the right or wrong answer.
Prior, I can't hear you. Sorry.
Officer, I appreciate your honesty and that there is no wrong or right answer. You're well aware of that. But again, like counsel for the prosecution has said, that's what this is about. And you keep me honest about your position. Greatly appreciate, Judge. I'll concur with the exclusion, and that's not to be taken personally. No. Thank you, sir.
All right, the court's considered the motion to strike the cause presented by the state, concurred by the defense. The court also concludes at this stage of the proceedings, there's been an indication that based on pretrial publicity and knowledge of the case, there's likely an inference of guilt that this juror would be struggling with, which will result in the court sustaining the strike. So thank you so much for filling out your questionnaire and returning today. And we will allow you to be excused. Please drop your questionnaire off with the bailiff.
Thank you, Your Honor.
Thank you. So next up will be 1048. All right, juror number 1048, thank you for returning for individual voir dire questioning. The court's first going to request counsel make inquiries as it relates to any previous case information, noting the juror has indicated in the questionnaire some knowledge of the case or related case based on media coverage. So I don't believe there's been an expression of any concern for hardship. So if the state would like to inquire on bias for voir dire, you can do that at this time.
Thank you. Thank you, Your Honor. The state doesn't have any questions in this regard.
All right, Mr. Pryor.
I can just help.
Okay. Just briefly to confirm here, juror 1048, you did say that you had heard of the defendant and what he was accused of due to media coverage. You also indicated you've not previously formed an opinion about his innocence or guilt. Is all of that accurate?
It is, Your Honor.
Okay, thank you for confirming that. Without further questions on that, then the next topic I want to discuss with you, juror 1048, relates to your attitudes regarding the death penalty, and that is part of the questionnaire starting on page 12. Do you recall reading those questions and answering those?
I do.
And did you take, I know it was a long questionnaire, did you take the time to really think through those questions and answer them as accurately as you could? I did. Are the responses you made there still the same as the way you feel about things today?
Yes, sir.
Okay, I am going to advise you that it might be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty in this case. And please remember that any penalty you are considering should be considered as if it is absolute and will be carried out in the case. So with that in mind, you first in your responses stated that when you had the choice between support or oppose the death penalty, you checked the box saying you support the death penalty. Is that correct?
Correct.
You also had certain choices that, not necessarily your words, but descriptions of what you think or what is most accurately would represent the way you feel. And that's on question 6. You elected option C, and that reads, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that still accurate as to how you generally feel about the death penalty?
It is, yes.
Okay. A final question I have then is, would you always be in favor of the death penalty in every case where a murder has been committed?
I don't think so. I think it would depend on the circumstances of the case.
Okay, and would you follow all of the court's instructions relating to the death penalty in this case if you were provided those instructions?
I would, yes.
All right, thanks for your responses. Moving to the state on that topic, is there any vote out from the state?
There's not, Your Honor.
From the defense?
Yes, Your Honor, just very briefly.
Very well.
And I always like definites. We can't always get definites in big statements, and I think you want to ask. You said, I don't think so. Could you expand on that a little bit for me?
What I meant by that is it really will depend on the circumstances of the case. I can't say that I would always favor it. It would just depend.
Okay. And I don't ever want to put words in your mouth. I want you to know what your opinion is. That's more important than anything. Not the state, not my opinion or anybody else's. What I'm hearing is that I'm not leaning either way, the death penalty or life in prison. My decision isn't either one. It's a neutral decision, and I'm only going to make that decision after I have all the facts and all the information. Is that fair?
That's fair.
Would that be more accurate if there was a choice on this list in the middle that said, I'm neutral, and only after I hear all the evidence will I make that decision?
If that would have been an option, I would have selected that, yes.
Okay, Judge, I have nothing else. Thank you. I'll pass it.
All right, thank you. We'll have you return for some further instructions here shortly. Thank you for your patience today.
Thank you.
Okay, next up is 1057. All right, welcome back, juror number 1057. We are going to conduct some individual voir dire at this time outside the presence of your fellow jurors. The first topic we'll just get right to is relating to questions of bias. You do have some prior knowledge of this case, and you've made some indications, including a statement that said the news makes them seem guilty, and that would include the defendant and a few other statements. You also raised your card in one question about whether or not you may already have an opinion in the case. So I'll allow the jurors to question you on that. And of course, in this setting, you're allowed to more openly explain in any detail of what you think you may already know and why you may feel the way you feel. So for the state, who's going to conduct voir dire?
That would be me, Your Honor. Thank you.
Okay, Ms. Beatty on bias, please.
Thank you. I want to talk a little bit about something that might be kind of painful for you that you referenced earlier, which was a situation with your brother-in-law. It sounds like he was burned at one point.
Yes.
And that you happened to be there.
And I took him out.
Okay. I don't want you to have to relive the entire story, but can I ask, is he okay now?
And this, I'm sorry to interrupt here, but if this is a topic you'd wish to discuss not in a public forum, we can do that, or you can discuss it in a public forum. It's up to you. Okay.
If I cry, I cry.
Okay. All right. Thank you.
And if you change your mind at any point and would like it to talk about it privately, that's okay. So he was severely burned, is that what you were saying?
Yes.
And did he have to get treatment for that?
He spent 6 weeks in Salt Lake and then there's been residual issues.
Approximately how long ago was that?
It was over 30 years ago.
Okay. And you mentioned that that particular experience might make it difficult for you to look at some photos today or during this trial.
Yes.
Do you believe that your personal experience in this case would prevent you from looking at the photos, or do you feel that it would just make it difficult for you?
It would just make it difficult.
Okay. Now, one thing that you're going to be instructed on during the course of this trial is that as Mr. Daybell sits here today in this courtroom, he's presumed innocent, and that all of the jurors need to give him the presumption of innocence until the state meet our burden of proof beyond a reasonable doubt. Are you able to give Mr. Daybell that presumption of innocence?
Yes, I said I would definitely consider all evidence.
Okay. Now, specifically with those photographs, understanding that Mr. Daybell is entitled to a presumption of innocence, would you be able to set aside your personal feelings and experiences and evaluate those photographs and weigh them along with the other evidence that you receive in this case?
Yes.
Okay. I would like to talk about some of the media coverage in this case as well, and I thank you for being willing to talk about such a difficult subject. You had mentioned that you had been exposed to some media in this case. And you had also indicated in your questionnaire that you would be able to put out of your mind what you have read and heard about this case and render an impartial verdict based solely on the evidence presented in this courtroom. Is that correct?
Yes.
Okay. Now, earlier, the judge asked all of the jurors if anyone had formed an opinion on Mr. Daybell's guilt. Do you remember that?
Yes.
And I believe that you raised your paddle.
I did.
Do you want to, would you be willing to talk about that with us a little bit?
I just, in my personal life, I've always been called honest to a fault. And I had a personal situation where somebody tried to get me to go do something that I knew was wrong. And if that person would have done that thing wrong, I would have turned them in. That's my issue.
Okay. So, could you elaborate on that a little bit as it relates to being here today and raising your paddle?
Well, my friend wanted to go confront her ex-husband who had been a little leeway with her daughter. And she said, and I'm taking my gun. And I said, I am not going with you. And then if she would have done that, and I knew that, I wouldn't try to hide it. I would call the police and tell them.
Okay. So do you feel that that relates to Mr. Daybell's case in some way?
Somewhat, yes.
Okay. And it sounds like that was a very difficult position that you were put in by your friend.
Yes.
But understanding, as we talked about earlier, that you have to presume Mr. Daybell innocent, do you believe you could set all of that outside of your mind?
I would do the best I could, yes.
Are you sure that you could do that? Just brutal honesty.
I probably am.
Okay, okay. I really appreciate your honesty, Your Honor, at this time. I think it might be appropriate to excuse Madam Juror for cause.
Okay. Mr. Pryor.
And ma'am, there is, and as Ms. Beatty indicated, there's no wrong answer, and I actually have high regard for you being so very honest in this thing. I greatly appreciate what the fact that you've done so today. I'm for it. I think that's consistent with your character, that you speak the truth. So I greatly appreciate it all. Judge, I concur with the state.
Okay, I've considered the state's motion to strike. I'll sustain that. So juror 1057, based on your potential bias here from previous media exposure to the case, the court very much joins in with counsel in appreciating your service and coming in, filling out your questionnaire, taking your time today, being involved in this process. This will conclude your jury service. You may be excused, and please submit your questionnaire to the bailiff as you leave today.
Thank you.
You're welcome. All right, before we conclude then, we're going to take a late lunch. We're off the record for the remainder of the day. The court wants to meet with counsel for further questionnaire reviews, which we'll do this afternoon. I'm going to propose we start that up at 2 o'clock. Is counsel okay with that as a start? I skipped a step. Thank you, everyone, for the reminder. We are bringing the jury back in for cause, and we'll inquire whether or not they're being passed. So while they're going to return, is the state okay with a 2 o'clock start time for questionnaire reviews?
Yes, Your Honor, that should be fine.
All right.
Yes, Your Honor. Thank you.
Very well.
All rise, please.
Thank you. Please be seated. All right, having gone through the small group here, remaining are jurors 752, 922, 951, and 1048. We've concluded voir dire. Does the state pass this small group for cause?
Yes, Your Honor, thank you.
Does the defense pass the group for cause?
Yes, Your Honor.
Okay, thank you.
Yes, Your Honor. Thank you.
Very well. Ladies and gentlemen of the jury, the four of you, you have now been passed for cause, so we're going to continue to question additional small groups until we reach the necessary number of jurors for the attorneys to exercise their peremptory challenges. You will be returning for that process, and you'll receive further instructions from our jury commissioner, Randy Rutland, who will advise you when you do need to return. Very importantly, between now and the time you do return, please do not do anything to end up biased in the case by looking into the case. So don't do any kind of investigation into the case, follow the case on the news, try to refrain from speaking to anyone about any of the facts of the case. You are, of course, permitted to talk to people, including family, friends, or employers, about your potential service in this case to make those preparations, but no discussion of the details or discussions about the case so that you can maintain your impartiality which you've demonstrated here today. So that will conclude your service for now. You will be returning. The bailiff will help you out for the day with your further instructions on when to return. And we appreciate your service to this point. But I'll please rise for the jury. Okay, we'll come back in for questionnaire reviews on the record, but outside of the public here for further review at 2 o'clock. Thank you, counsel, and we'll be in recess till then.